The topic of my discussion is lawfare, how to thwart the shariah threat. First, let's understand what lawfare is. Lawfare is quite simply the use of the courts, litigation, to change policy and behavior. Now, we all understand that lawfare has been around now for a century at the very least. The ACLU was really the first organization to employ lawfare effectively and in a concerted fashion. And they were extremely successful in the 20th century, changing not just law, but actual behavior of law enforcement personnel, politicians, government officials, and the public. Across the board, ACLU's success through litigation and through staged litigation, not just litigation that came, as it were, fortuitously, but litigation that they literally set up and managed so that they could achieve the policy end that they were seeking to achieve. With the success of the ACLU toward the latter part of the 20th century, certainly by the 80s and 90s, we had many of the conservative groups, and especially groups that are represented here, Jay Sekulow's ACLJ, the Alliance Defense Fund, the Thomas More Law Center, Christian public interest law firms, conservative public interest law firms, and of course other progressive and left-wing public interest law firms fighting on behalf of the environment or whatever the issue was. And the reason you had this convergence in the courts is precisely because the courts provide a unique opportunity to change policy in ways that you can't do behind the scenes or in a grassroots way. We won't go through the mechanism of lawfare and why it's necessarily more effective, because it's only, my time is fairly limited. But the aspect to lawfare that we should focus on is what is the purpose in the context of fighting the shariah threat, and what makes this particular battle space unique and different from the other battle spaces that we find ourselves in the conservative side. So we might ask ourselves, is the lawfare fight against shariah different from, for example, the standard First Amendment free exercise issue that might be raised by a Christian public interest law firm? First of all, lawfare seeks to effect a strategic and a tactical end. Strategically, lawfare seeks to literally change the law through rulings in court. So if you challenge, for example, as we have in our lawsuit against the administration and Obamacare, we literally hope to change the law by getting the Supreme Court of the United States to hold that Obamacare was unconstitutional. Similarly, we sued the Treasury and the Fed for the takeover of AIG, which was the largest shariah-compliant insurance company in the world. Our argument there being that the government cannot be in the business of promoting shariah insurance because that is a violation of the Establishment Clause. And if the courts ultimately rule in our favor, and we are now, our case has been fully briefed in the Sixth Circuit, we're simply waiting for oral argument, we will have changed the law as to what the government can and cannot do in the realm of shariah finance. So those are the kind of strategic changes. Tactically, you seek to change people's behavior. Now this is where the lawfare that we are engaged in is not merely defensive. We're not simply defending individuals' rights. We've done that. We've done it for Pamela Geller, of course. We've done it for the Center for Security Policy. We've done it for many organizations and individuals. But the lawfare that we need to be waging against shariah has to have a very, very hard-nosed offensive component, meaning that you have to be prepared to sue the Muslim Brotherhood Sharia adherent organizations. Again, we're doing that in our lawsuit against CARE, where we've alleged fraud and a cover-up and so forth. in order that the next time they think about having to deal with you in the public domain or even in the private domain, they're going to modify their behavior because they have to calculate, just like we do on our side with the threat of lawsuits, defamation, or whatever it may be. They have to calculate what is the cost of this litigation. What is it going to do to our public image? How much is it going to cost for legal fees? And how long are we going to be tied up in court, in depositions, in dealing with discovery? Those kinds of decisions, that calculus by the bad guys, will change behavior in the same way we know it changes our behavior. That is to say, the good guys will oftentimes not write a book, modify an op-ed, use a different term out of fear of being sued, out of fear of ending up subpoenaed in some litigation. The same calculus operates on the side of the shariah adherents. I want to address now the question for the lawyers in the room, for the representatives of public interest law firms. The question that they have to confront: is this battle space an area of lawfare that they are prepared to enter? They can't take that decision lightly. They have to weigh both the cost, we'll talk about that, both financial and reputational. They have to weigh the impact it's going to have on their constituency, typically their donor base. They're going to have to weigh the personal cost of what amounts to a very, very acrimonious, publicly hostile arena. Let's cover, for this part of this my talk, the factors that must be considered by attorneys who think about defending or prosecuting a litigation involving the shariah threat. First of all, the typical public interest law firm is not fact intensive. The facts are pretty straightforward, and you're more or less arguing over whether or not the facts as they are agreed upon by the parties violates the Constitution or not, typically the First Amendment. In this area, the battles tend to be extremely fact intensive. Our litigation, for example, against AIG required us to do discovery on AIG through third-party subpoenas with subsidiaries all over the world, including in Muslim countries, with Arabic documents. We had to deal with all of those logistical issues. So you have extremely fact-intensive cases, which means you're going to expend a lot of attorney and paralegal resource time in these matters. The second element, which is different from your typical case, is that you are going to be attacked viciously. You will be attacked professionally by the Muslim Brotherhood and the progressive left, who have joined hands in this battle space. You know, when we fight in the standard First Amendment, pro-life, Christian issues, you're attacked by the left, but things still remain fairly civil, although it is true that in the pro-life area it can get nasty as well. But it gets even nastier when you go after shariah or any Islamic issue. The Islamophobia narrative machine gins up, and you will be called every name in the book. There will be bar complaints waged, sanctions sought. It is the standard operating procedure. And by the way, discovery never goes easy. You fight for everything. So the litigation itself is not atypical if you're a hardcore litigator, but it is hardcore litigation. There is nothing buttoned down about this. This is roll up your sleeves. You're going to get bloodied, but at the end of the day, you hope to draw more blood than you've lost. The other aspect which is different in this litigation is you can't simply be an expert in the First Amendment. That won't cut it. If you don't know it, typically the specifics of shariah that you are looking at in your particular case, whether it's Sharia compliant finance, whether it's the national security threat, whatever it may be, you have to be an expert in that. You cannot rely on other experts. You will use other experts because you certainly, as the advocate, are not going to be the expert for your case, but you have to be able to prepare the material. If you have to rely on the experts, you will not have a forensically coherent presentation, because the experts in this particular field tend to be bloggers and philosophers and theologians. They don't have the forensic expertise that if you're getting an expert psychiatric exam, you go to a forensic psychiatrist, or if you need an accounting for litigation, you go to a forensic accountant. In this sphere, you have very few attorneys, experts who have the forensic aspect to their expertise that allows them to testify cogently. In addition, if you're dealing with one of the main stealth threats, Sharia compliant finance, you have to know securities law. If you're not expert in that area, you're simply not going to be able to enter this arena and do battle in this space and come out with a victory. And a victory doesn't have to be, as we all know in lawfare, a judgment. But it means that you cannot be booted out on a motion to dismiss and provide the other side with the moral victory that you didn't draw blood. In lawfare, you've got to get into discovery. You've got to be able to make your case. You've got to be able to present the facts, because that is really the major advantage to litigation. In court, even if you have a progressive judge, the facts create a level playing field. And once they're in the record, even if you lose, and then you take it up on appeal and create your appellate record, that then becomes the facts of the case, the law of the case, and even if at the end of the day the opinion or the judgment is against your client, that survives and can always be pointed to later on. So to sum up, lawfare against the Sharia threat is probably one of the most effective tools we have. We have others, and I know Chris Holton is going to speak about the American Laws for American Courts, legislation. We have policy. We have grassroots activism. There are a lot of different tools, so I don't want to pretend that this is the only tool, but I know as a historical fact that lawfare is one of the most effective tools, both in terms of changing law, changing policy, changing behavior, and also for purposes of public relations, because nothing grabs the attention of the media more than a battle in court with the drama of courtroom narratives and testimony. I wish everyone in this conference success. It's, again, an important endeavor, if not one of the most important endeavors. The battle between patriotic Americans, and I don't use that term lightly, against the Muslim Brotherhood progressive syndicate that has formed around the issue of Islamophobia is critical. And I applaud all of you who are involved in this area and are fighting the good fight. Thank you.